And we are live. Greetings, my brothers and sisters, wherever you are, whether living in Nigeria or outside Nigeria. I bring you warm greetings and welcome to today's program on this wonderful show called Nigerian Constitution and Your Right, or Nigerian Constitution, Know Your Right. We bring you this program powered by the Global Coalition for Security and Democracy in Nigeria every Tuesday, 9 p.m. Nigerian time. We take various segments or chapters or sections or subsections of the Nigerian Constitution 1999 as amended. We talk about them, we try to explain them or break it down to our fellow Nigerians so that they can understand the law, understand what is contained within the Constitution, so that they can be able to utilize it to stand their ground and to fight for their right as law-abiding citizens of the Federal Republic of Nigeria. And today's topic is a continuation of the series that we have been doing for the past 4 weeks, of the 14 fundamental rights of Nigerians. The 14 fundamental rights of Nigeria can be found in Chapter 4 of the 1999 Constitution as amended, and it has about 14 it's spelled out within 14 sections of chapter 4, which is section 33 through section 34. We have done 4 of the 14 so far. That means we've done section 33, section 34, section 35 last week, and this week we are doing section 36. And I've been inviting lawyers or legal practitioners in Nigeria to add to the conversation to help our fellow Nigerians and fellow citizens understand the law as it is, as enshrined in our Constitution. And today I have a guest, or maybe 2 guests. Let's see if they're ready. Yes, I have 2 guests. So let me invite them to the program as we continue. Please, Barrister Eldridge, can you I don't know, I'm trying to have issue getting you to, can you go out of the studio and come back in? For some reason I can't add it to the stream. I'm only able to add Mr. Obinna Najafo, or Barrister Obinna Najafo. Please welcome to the show. Introduce yourself to the audience and say 1 or 2 things on the topic today. The topic is, does Nigerians have right to fair hearing? Opening statement. Greetings and opening statement.
Greetings, Mr. Edmond, Ikeh, and hello, everyone. It's a great privilege to be invited once again on this show. It's my understanding that today we will be talking on whether Nigerians do have a right to fair hearing. Well, it is quite a catchy phrase, since I've been a part of this program on educating people as to whether Nigerians do. Perhaps that comes in a straightforward yes or no answers. But I suppose the objective of this show is to go beyond answering or affirming or negativing the existence of such a right, and then expatiating, making elaborations on how such right exists and how it is practicable in the Nigerian atmosphere. So, of course, the answer would be a yes, because the said right is expressly captured by Section 36 of the Nigerian 1999 Constitution as amended. So, by virtue of such right, by virtue of the enactment, it is safe to say that Nigerians do and have been guaranteed the right to fairly in every area of their dealings. Well, the right to fair hearing generally means two things. One, it means the right for the other side to be heard. What is usually captured in the Latin maxim as audi utra partem means hear both sides. Hear both sides. That is one aspect of fair hearing. And the other aspect of fair hearing is what is called, what is described in Latin as nemo judas in casus. You cannot be a judge in your own case. So on these two bases and on these two standards, the rights to fundamental or the rights to fair hearing are ensured, or it is on these two bases or on these two standards that the right to fair hearing can be realized. So if I may go further, speaking on the aspect of the right to fair hearing, I mean, that is a right that is so that exists and is so as ancient as mankind, as if I may say so. Even from the time in the Bible stories, from the time of Adam and Eve, even Adam was given a chance to explain why he ate the apple. God didn't go straight ahead to, even though he knows all things, but he didn't go right ahead to condemn him. He gave him a chance to be heard in the circumstance. Okay, so the right to fair hearing, the importance cannot be underscored, because the moment you deny a person the right to be heard, you're effectively saying this person is not a human being. Mind you, the reason why rights, so to say, are couched as fundamental, or this right is couched as fundamental, is because it is so important to existence as human beings. These are the rights that you attach to a human being, and then the person will rightly be perceived as a human being. If you deprive a person of these fundamental rights, then it is rightly be said that you are reducing the person to a status lesser than that of a human being. So the right to fair hearing, like I earlier said, connotes hearing both sides before coming to a conclusion. And the other aspect being that you should not be a judge in your own case intimates that you should, or rather, in a case where you are a party, and an independent party or an independent arbiter should be able to decide as to who is right, because mankind is selfish. If you were to be given the opportunity to decide in your own cause or in your own matter who is right, you will definitely decide it in favor of yourself. Hence, the natural principle that you should, or rather, where a judge shouldn't be, where you are a party to a cause or matter, you shouldn't be a judge in that matter. And where you are a judge in that matter, the proper thing to do is to recuse yourself, to withdraw yourself and hand over the matter to an independent arbiter or umpire to determine the situation as it is in the interest of justice.
Thank you very much, Barrister Obina. You've given a very strong opening statement, and I hope the audience are listening and paying attention and learning from what you're saying, because the purpose of this show is to educate the Nigerian populace, to educate the Nigerian masses so that they can understand their right as citizens of the Federal Republic of Nigeria and apply so accordingly. So I'm going to take a few comments and then take a break. And when we come back, we'll delve into, we'll actually read the kind of some part of the section, subsection of the section 36, and then I'll ask you some specific questions as we move along. Sounds good? All right. We'll have a comment from Rita. Says, hello, everybody. I hope I'm not too late yet. Good evening, Rita. On the show. I think I always consistently participate. We appreciate it very much. Please keep coming back. I will bring to the show. Ask them question and learn from the learned and because this will bring them invited to the show so they can prefer more understandable explanation of the law. So thank you very much. And that's the only comment we have for now. So we will take a quick break and then we'll come to questions. So please, if you have questions, send it over so that Barrister Obinna will answer your question.
See the bridge. We collapse here. Bike they follow here pass. Then motor they follow this other side pass. Then see the hill. See the hill up. This one to the hill up, no get problem at all. Nothing can just come down.
Welcome back. Thank you for going without that break. I said I'll show that video every Tuesday to create an awareness to the public and also more specifically to the government of Anambra State to pay attention to that bridge that have fallen since September of last year. And the proposal was sent to the last administration of Willie Obiano, but nothing was done for the people of Obofia, ward of Agwata local government, Anambra State. So we hope that the new administration of Charles Chukuma Soludo will pay attention to those people and then help rebuild a bridge, a better bridge, hanging bridge preferable, that will last longer for the people. So back to the show. Today's program, Nigerian Constitution, Know Your Right, Nigerian Constitution and Your Rights, powered by the Global Coalition for Security and Democracy in Nigeria, every Tuesday, 9 p.m. So please invite your friends, your brothers and sisters to the show so that they can learn about their rights, so that they can be emboldened to exercise their rights in Nigeria and as citizens of Nigeria or as law-abiding members of the society. And today's topic, does Nigerians have right to fair hearing? That is the topic for today. And the learned barrister have spoken very clearly and very understandably that the Nigerians do have a right to fair hearing, and I think he did a wonderful job explaining it. And hopefully the questions that is going to be posed to him is going to help him dive into it properly to explain better so that Nigerians, whether educated or non-educated, will be able to understand it and be able to be encouraged or emboldened to stand by their right and demand for their rights to be respected. With that being said, so barrister, I'll ask you the first question before I read the constitution. This question is due to an interview by one of your colleague, your learned colleague. He's a constitutional lawyer and a human rights advocate. He mentioned that that virtual court is unconstitutional. And we know virtual court, if in the Nigerian context, people's hearing have been delayed because the court have backlog of cases that difficult to attend to. So, and people are providing the idea or preferring their suggestion that maybe virtual court hearing will help solve this problem of people not being able to be heard because there's no slot in the code or things like that. So virtual hearing can help alleviate that problem or can help solve that problem. But this lawyer, Barrister Mokedike, I think his name, he said that that will be unconstitutional. So I want to hear your take on that, the constitutionality of virtual court hearing, and would it be able to help solve the problem of not hearing people because there's no room to accommodate them in the court or due to backlogs?
All right. Thank you for the question. Like you rightly pointed out, it is his opinion, and I think I would be, I think my opinion would differ from his. I think my opinion differs from his. I do not contemplate virtual court hearings as amounting or tantamounting to an infringement to the guaranteed fundamental right to the guaranteed fundamental right to fair hearing granted to citizens of Nigeria. And why do I say so? Firstly, in the layman understanding of what fair hearing is, it simply means hear both sides. Now, virtual court hearing, in all of my understanding and the practice of it, does not impinge on the ability or the capability of hearing both sides. Are you with me? For instance, in a virtual court hearing, for instance, I think virtual court hearing, an instance of, let's assume this session right now is a virtual court hearing. Let's assume you are the umpire on the judge, and I am one of the litigants, and the other, or perhaps counsel to the litigant, and the other lawyer whom you invited to be a guest on this show is the lawyer for the opposing party, or the opposing party as the case may be. You would agree with me that both of us are equally heard by you. Am I correct? Both of us are equally heard by you. When you asked me to speak, I speak. When you ask the other counsel or the other lawyer to speak, he speaks. And this is the same thing that transpires in the very courtroom. The Constitution which we are referring to did not in any way stress that the courts or the tribunals are only entertained to entertain the physical appearance of a lawyer or of a counsel or of a party before it. So I do not think there is any room to infer strictly that the fact that such virtual hearing was not expressly accommodated in the Constitution, and that nullifies it. In the first instance, the physical appearance before the court is not in any way expressly captured in the Constitution.
Yes.
So
okay.
You see that
I want to add that before you continue your view, I think so far from your explanation, I think we are aligned. We have similar view in that matter. But I want to hear your view. He made this argument quoting section subsection 1, 3, and 4 of what we are talking about, the section 36.
Yes, and I was going
trial being held in public.
Yes, I was going to go further. Okay, to make reference to section 36. 36 36 sub 4.
Yes, subsection 4.
Subsection 4, 36 sub 4, paragraph A, which reads, the paragraph A creates exceptions to instances where the court can entertain proceedings in the absence of the public. Are you with me? And if I may read, this said subparagraph A expressly says, a court or such a tribunal may exclude from its proceedings persons other than the parties thereto or their legal practitioners in the interest of defense, public safety, public order, public morality, the welfare of persons who have not attained the age of 18 years, the protection of private lives of the parties, or to such extent as it may consider necessary, by reason of special circumstances in which publicity would be contrary to the interest of justice. Now, I would want to point out that the aspect of the introduction of virtual court hearing of cities in Nigeria arose during the preeminence of the COVID-19 era. And this the emergence of the COVID-19 and the pandemic nature associated with it was necessary and rightly accommodated under public safety. So, if in the interest of public safety, I do not think that virtual court hearings adopted for the sake of curbing the growth or curbing the rise in COVID-19 cases is anyway unconstitutional. And my opinion is that same is expressly backed up by this provision I just relied on. So virtual court hearing and virtual court sitting in any way, I do not reasonably see how same can amount to the infringement of a person's fundamental right to be heard. I do not think so.
All right. Thank you very much for your postulation. Thank you for that explanation. I appreciate that. So I'm going to take this opportunity to read some section. I won't be able to read all the sections because subsections of section 36. It's about 12 subsections, so that's too long. We'll read the first 4. Section 36 of the 1999 Constitution as amended reads as, in the determination of civil right and obligation, including any question or determination by against. Am I reading the right thing? Give me a sec. Yeah. Yes, I'm in the right section. Okay. So in determination of his civil right and obligation, including any question or determination by or against any government or authority, a person shall be entitled to fair hearing within a reasonable time by a court or other tribunal established by law and constituted in such manner as to secure its independence and impartiality. Without prejudice to the foregoing provisions of this section, a law shall not be invalidated by reason only that it confers on any government or authority power to determine questions arising in the administration of a law that affects or may affect the civil rights and obligations of any persons if such law A, provide for opportunity for the person whose rights and obligation may be affected to make representation to the administering authority before that authority makes the decision affecting that person, and B, contains no provision making the determination of the administering authority final and conclusive. And then subsection 3, the proceedings of a court or the proceedings of any tribunal relating to the matters mentioned in subsection 1 of this section, including announcement of the decisions, the court or tribunal shall be held in public. Subsection 4, whenever any person is charged with a criminal offense, he shall, unless the charges is withdrawn, be entitled to a fair hearing in public within a reasonable time by a court or tribunal, provided that A, court or such a tribunal may exclude from its proceedings persons other than the parties thereto or their legal practitioners in interest of defense, public safety, public order, public morality, the welfare of persons who have not attained the age of 18 years, the protection of the private lives of the parties of such extent as it may consider necessary by reason of special circumstances in which publicity will be contrary to the interests of justice. B, if in any proceeding before a court or such a tribunal, a minister of the government of the federation or commissioner of the government of the state satisfies the court or tribunal that it will not be in public interest for any matter to be publicly disclosed, the court or the tribunal shall make arrangement for evidence relating to that matter to be heard in private, and shall take such other action as may be necessary or expedient to prevent disclosure of the matter. We'll stop here for now, and based on the last subsection 4b, They said there is a provision that allows some matters to be held in private, as highlighted in subsection 4b, but naturally, as it said, cases have to be held in public, right? So how does this special situation that allow certain matters to be held in private, how does it affect the Nigerian population at large? Please, can you throw a light on that?
So sorry, I need you to kindly rephrase the question.
I should rephrase.
Or
In
repeat the
subsection,
question.
The question is how, like in usually from subsection 1, 2, 3, it's stated that cases should be heard in public or trials should be heard in public. But in subsection 4b, it said in some situation, okay, make arrangement. Okay, let me read it out. Say, the state satisfied court tribunal that will not be in public interest. So when it's not in public interest for any matter to be publicly disclosed, the court or tribunal shall make arrangement for evidence relating to the matter to be held in private and shall take such other action as may be necessary or expedient to prevent disclosure of the matter. So this allowance of the law to hold certain cases or certain trials in private, how does it affect Nigeria, the masses of Nigeria? How does it affect us directly as the masses?
Okay, all right. Well, to start with, first of all, the Constitution is the ground norm of laws in Nigeria, and any other act, law, or anything inconsistent with the provisions of the Constitution is null and void and of no effect. Okay, so when the Constitution has provided for a thing, you do not go contrary to the Constitution, save and except same is amended. So despite any negative connotation that may be associated, or maybe lacuna or weakness, or no matter the disaffection associated with the said section, the truth still remains that it is the law. Are you with me? And the law would have to be observed. Now, coming to, I understand that in a country like ours, the said provision may and is prone to abuse. Is prone to abuse, especially with the lack of independence of the judiciary. Because as the said section you rightly stipulated, it has to be upon the judge, the court, or the tribunal being satisfied that same is in the interest, that the non-disclosure of same is in the interest of the public. But you will agree with me that in a normal Nigerian setting, one expects that the judges are rather coerced instead of satisfying them on the reasonability thereof. Do you understand me? So yes. I think the only challenge associated with the application of that provision has a lot to do with the independence of the judiciary, a judiciary that stands for the common man, a judiciary that stands for the right of the public, a judiciary that understands that the acts of the executive are subject to scrutiny, and that they cannot rely on this to evade the necessary fair hearing that should be done in a matter, or that should be brought, information that should be brought to the knowledge of the public, as the case may be. So I think the challenge is predominantly that of the judiciary. It is when the judiciary allows the executive to whom such privilege has been accorded to abuse it. That is when it will pose a problem to Nigerians. But if the judiciary would not allow their independence to be trampled upon, and would determine such requests on the merit, I believe it would achieve its goal, and the concerns about it being abused would be a forgotten issue.
Thank you very much for that input. And you made a very salient point about the judiciary not performing their work or being a check to the executive abuse of the law. It's the executive that usually abuse the law, and the judicial just condones it. The court, why I was asking in that regard, because the public have a like public outcry, public uh, uh, talking about what about this matter that I had in private. We don't know the outcomes. We don't know how it went on. We don't know if there's anyone that was found guilty. We don't know if there's anyone that was prosecuted or jailed. We don't know anything about that. And yes, the law allows that, but we don't know how it favors us. Like instances, people having crying out that Boko Haram have been terrorizing the northern, a whole region of the country, the northeast, northwest has been terrorized for years, for more than a decade. And they said some of these terrorists have been arrested and some of them have gone to court. Oh, we don't know which court they went to. We never heard about them. They say the trials are held in private, in private setting. Okay, we don't know who. So one of the northern politician APC candidate mentioned about a week ago or so in the national TV that about 500 Boko Haram terrorists have been tried. 500 when? When? We don't know. So about 500 have been tried. So what was the sentence? And then we are hearing, we also hear about thousands of Boko Haram people have been pardoned, have been forgiven because they are repentant Boko Haram. So these things. So are these repentant Boko Haram part of the 500 that have been tried privately or secretly, or are they different? So we need to know all these things. So hence the question. So I wanted to throw more light. So in this case now, that will have supposedly 500 Boko Haram that have been tried and secretly. So how can the Nigerian population find comfort to know for sure that indeed that has actually taken place?
Well, I think at this point, this is a question that borders on the integrity of the judiciary, as the case may be. I think the judiciary should do more in getting the public to repose more confidence in them, because this is a right, and this is a right that has been afforded and accommodated under the law, and particularly the almighty Constitution of the Federal Republic of Nigeria. And you and I will agree that notwithstanding the fact that these instances are being applied in the case of trials relating to Boko Haram suspects, but you will agree with me that there are still peculiar situations in the interest of what is called national security that such measures would be adopted. Are you there? Such measures would be adopted in the interest of national security, as the case may be. So it is only proper that matters related to national security, the public, in the interest of the well-being of the nation, the public should be. I don't know if I can hear myself. I don't know if it can be it's distorting my flow a bit.
I can hear you. Something happened. That was why I could. Yeah, go ahead. I can hear you.
Okay. All right. Thank you. So as I was saying, so you would agree with me that there are circumstances, peculiar circumstances, where it becomes apt that the provision of the Constitution highlighted is ought to apply, or is justiciable or justifiable in the circumstance. Now, coming down to the aspect of the Boko Haram secret trial, you agree with me that the issue of the Boko Haram terrorism is one which affects the security of the nation. And if the public are perhaps accommodated during the trials of the Boko Haram suspects, some vital secrets relating or that are fundamental to the national security could be disclosed. And this fundamental information could create unnecessary fears and unnecessary issues and disaffection among the public. Okay, so I am not privy to the Boko Haram trial going on, or the trial of the Boko Haram suspects going on.
Of course,
like I said, of course, none of us are privy, except for perhaps the councils that are involved in the matter, okay, or any other party personally involved, such as the witnesses who give evidence against the Boko Haram suspects. But like I did say, this is a scenario or an event which calls on the judiciary to elevate their integrity in such a way that it is manifestly seen by every nook and cranny of the public, such that they can, notwithstanding the fact that the proceedings are done in camera and out of the public's face, but the public trusting the independence of the judiciary and their integrity to do justice can trust the outcome at the end of the day.
All right, thank you very much. We're going to take another quick break, and when we come back, I'll ask you about 2 more questions and then your closing remarks so that we'll finish early today. Last week, we extended our time to almost over 50 minutes. So we'll try to finish today in 40 minutes.
It was purely an hour session.
I'll be right back.
All right.
This is a community called Lara community in Moro local government area of Kwara State, Nigeria. This is their source of water supply. They drink from the pond like drinking from the gutter. They drink from the same pond with goats, with cattle, and with dogs. They take the water home to take their bath, to cook, and to drink. Sometimes they put alum before they could drink. Is this permissible in the 21st century? These people need our help. Please, the Global Coalition for Security and Democracy in Nigeria is calling on you to join us to drill a water borehole for these people. Let us do this. It is possible. This must not be allowed to continue. No. No. No.
All right, welcome back. So that is a project the Global Coalition for Security and Democracy in Nigeria is handling, trying to provide water, drinkable water for the people of our community, Moro local government of Kwara State. So if you have any support, you can support the project at the account number and shown on the screen for UBI account of Rita Ajejive, that's coordinator handling that project. The UBI account 20320124464, and in the memo just write water 2022 so that you know what funds, what is the funds for. And after the project has been executed, the Global Coalition for Security and Democracy in Nigeria will surely publish the expenditure of that project. The coalition have been doing projects every year since 2020. They did one in 2020, one in 2021, and this is going to be the 3rd project being executed by the coalition. So please support, and God will bless you richly. Back to the show. Nigerian Constitution on your right, focusing specifically on Section 36 this Tuesday. Does Nigerians have right to fair hearing? The learned colleague, learned barrister in the studio have answered that question that yes, Nigerians do have right to fair hearing, although maybe that right is not being upheld often because some Nigerians don't even know that they have that right. Hence the purpose of this weekly program, so that you can learn about your right and learn to be emboldened to exercise your right freely and confidently, because this is your fundamental right as a Nigerian. So back to the topic of the conversation. I have 2 more questions for the barrister. In subsection 6 D, it mentions that the Nigerians do have right to examine the witness that is brought to the court of law. So what does that even entail? What does that even mean, to examine a witness that was brought? Is it your own witness or the witness that the lawyer, the prosecutor is bringing? Which witness? We don't know.
Okay, all right. Well, the provision is referring to scenarios where a party or his counsel. Okay, let me put it this way. Your issue is who is the witness in the question referred to? The witness is the witness on the other side, the witness of the party on the other side. Okay, if I can use an instance or a scenario that plays out in court, as using the instance of a scenario, to explain this particular highlighted provision. Let's say I am a litigant and I have a counsel, by the way. The said provision posits that I have the right to represent myself or elect a counsel of my choice to represent me in a court or tribunal proceedings. Now, the section also went on further to create the right for a litigant to, where in the instance of a litigant who decides to dispense with a counsel putting up an appearance for him, he can personally, because there are two aspects of examination of a witness. You have examination in chief and you have cross-examination. Examination in chief is where you as the party calling your own witness leads him to give his evidence in that case. And cross-examination applies where you as the adverse party in that case cross-examines or questions the adverse party's witness on an evidence he led before the court. So the law or the highlighted provision of the Constitution that was just read also went further to create a right whereby a litigant can by himself dispensing with the need for a lawyer to either examine his witness in chief or cross-examine the adverse party's witness. I hope I hope I'm understood.
You've answered it properly. Thank you very much. I just hope the audience understand that. I'm going to read the comments, then come back and ask you final question before your closing remark. Okay, we have one comment here. Yeah, this is a comment from the handler of Global Coalition YouTube page. Say, thank you for this program. It is good that you are inviting lawyers to participate. I hope Nigerians will be joining this program every Tuesday. Kudos. Thank you very much. Thank you very much. We also hope more Nigerians participate in this show, and because this is streamed in various platforms, so it's not just it's streamed on the GCSDN YouTube page, my personal YouTube page, and also on Facebook and Twitter and some other platforms. So I hope people take advantage of these various platforms to watch the show every Tuesday, 9 p.m. Nigerian time. Okay, that is all the comments we have for this week. I hope more people will participate in comment and actually ask questions. I want people to start asking questions in the comment section to the guests or to me if they so wishes. So one more question. These questions are going to be in the subsection 11 and subsection 12. Subsection 11 is no person who is tried for a criminal offense shall be compelled to give evidence at trial. So you explain what that means, but I want to add other questions so that I can answer them together before I close the remark. And the next question is on section 12 that says, subject as otherwise provided by this Constitution, a person shall not be convicted of a criminal offense unless that offense is defined and the penalty therefore is prescribed in a written law. And in this subsection, a written law refers to an act of the National Assembly or a law of a state, any subjudiciary legislation or instrument under the provision of the law. So the first one was about subsection 11. What evidence are they talking about? No person shall be tried for a criminal offense that shall be compelled to give evidence at trial. So what are they saying? What do they mean by that? Because it's not clear to the layman. And then 12,
okay.
What does it mean?
Yeah. All right. Thank you. The said section. Okay. Let us start by going this way. For an act or omission to constitute an offense, there are three principal ingredients or three principal ingredients that must be present for an act or an omission to qualify as an offense. One is that it must be written in a law, either by an act of National Assembly or by the law of the State House of Assembly or by any subsidiary legislation. But it must be in written. That is the first. It must be written. Secondly, it must be by an act of the National Assembly or an act of a state assembly. In other words, it is only the National Assembly and the State of Assembly that can designate what it constitutes an offense. Okay? And then thirdly, for an act of omission to further qualify as a crime or as an offense, it must, the written law must provide a penalty or punishment for the contravention of that law. So these qualities or these ingredients must be present before you can be rightly said that a person has committed a crime. And I want to use a popular instance that is usually and regularly being abused, especially in this part of the Southeast, where same has not been enshrined in any written law of the State House of Assemblies as a crime. Now, an instance is adultery. An instance is adultery. As magnifying as that act may be, do you understand me? It is surprising that in the southern part of Nigeria, it is not an offense. It is not a crime. But in the northern part of Nigeria, it constitutes a crime.
In the penal code system.
Yes, by virtue of the penal code. But in the criminal code, which applies to the South and to the Federal Capital Territory, Abuja, the adultery is not designated, or the act of adultery is not designated as a crime. But here, when such instances happen, you see people reporting such incidents to the police, using the police to arrest such a person. Do you understand me? And like I earlier pointed out in the last session, police jurisdiction is only actuated where a crime has been committed. So it is not right to utilize the police to pursue a civil grievance. Adultery is a civil grievance as far as the southern part of Nigeria is concerned, because it is not codified in any law applicable to the southern part of Nigeria as constituting a crime, and there is no punishment attached to such act. Okay, so this is one peculiar instance where such is usually being misconceived as a crime, whereas it is not a crime. So there are instances of so many abound, and it is only right that when a citizen of this country is arrested, it is important, and that is why this same section also creates the right that one should be informed promptly of the offense allegedly committed upon arrest. So it is your right for you to query the police officer upon an arrest to ask for what crime have I been arrested. And believe me, the police officer cannot give you or cannot allege any crime that has not been codified. And when he does allege any act or conduct that does not constitute a crime, in effect, he has exceeded his scope of jurisdiction. And to that extent, the arrest, if any, becomes unlawful. The detention also becomes unlawful. And on that premise, you can sue the police for the infringement of your fundamental right, having been arrested on no existing crime. It is even a breach of your fundamental right. It is even sufficient if you can back it up by evidence that at the point of being arrested, you inquired or you asked the police to inform you of the offense you committed, and they refuse to inform you of so. If you can back it up by evidence, that alone is a fundamental right, the breach of which will entitle you to an action to file a suit against the police. It is a breach of fundamental rights still. So
thank you.
I believe
thank you very much. Thank you very much. You've explained that very wonderfully. Our rights should be respected and upheld at all times. And if the police infringes on our right, we should always speak up and, if possible, take a legal action against the police or even the entire police department. And that is why we are doing this show, to teach people about their fundamental rights and their rights as citizens of the Federal Republic of Nigeria. I'll read a comment and I'll give you 1 minute. Please give me 1 minute for a closing remark after reading this comment, because we're out of time. We're back at 15 hours. Hoping to end at 40 minutes, but we have 50 minutes. Comment. Edith ID said, good info. Yes, we'll provide good information here for all Nigerians. Thank you for watching and keep coming back. Invite more people. We need more participants to come and ask questions and learn every Tuesday, 9 p.m. Nigerian time. And here, Rita said, the Nigerian police will say, you will know when we get to the station. Yeah. Yeah. And that is unlawful, as the good barrister said. It's unlawful.
Yes.
It's unconstitutional. They're supposed to read out your rights for you. Even the section 36 I did today, I think subsection 8 or so, said that your offense had to be read out to you in the language you can understand. And if you can't understand English language, they will bring an interpreter to interpret it for you. So this is guaranteed by our laws. So that is why we're doing this, for you to know your right, to stand by your right and defend your right at all times. I think that's it for the comment. And I'll give the floor back to the good barrister to give your closing remark. What do you want to tell Nigerians today?
Okay, all right. For my closing remark, I will start by pointing out that what is popularly known as trial by the social media in itself constitutes a very gross violation of the fundamental rights to fair hearing guaranteed to suspects who are alleged to having committed any crime. News are buzz these days of people running to conclusions without having the opportunity of hearing both sides. This is one of the major instances where almost every Nigerian is at fault or is guilty of infringing on the fundamental right of the right to fair hearing of another. Now, in every scenario that the social media has been agog with the allegation of a person having committed so and so crime, you see people, you see the people in the social media running to very hasty social media conclusions without allowing the course of justice to take its place. As rightly posited by the section 36 sub 1, fair hearing can only be actualized by through proceedings in a court of law or in a tribunal established by law. So the Nigerians have to understand that for a person to be afforded his right to fair hearing, he has to go through the process, or he should rather be subjected through the nitty-gritties of passing through the court of law, who will then receive evidence and facts on which to act on the situation involved. So I would also want to utilize this situation to ask Nigerians to take it down take it easy when it comes to spurious allegations that are made on social media. I would not condone the commission of any crime, but it is necessary that each and every one of us has to, as much as possible, endeavor to hear the both sides before you pass your judgment. And Nigerians should not frown at any point in time where a person or a person allegedly who is alleged to be a suspect, because the person is a suspect. It is until the person passes through the court procedure or the tribunal procedure that is when the person may be found guilty or not. And until the guilt or the person or otherwise is proved or established, the person remains a suspect. So Nigerians should refrain from passing on judgments on suspects until their guilt have been proved in a court of law or tribunal, as the case may be. So notwithstanding the fact that we do not like the incidents that happen, let's say for instance in the case of the popular gospel singer Osinachi, definitely all our fingers are pointed at the, but believe me, every accusations that has been led so far or that are available in the social media space have been one-sided. I don't think there has been any account so far from the man. Are you with me? And the man he will be, I believe he will be arraigned, or I don't know if he's yet to be arraigned in court for
him. He was arrested, but I don't know if he's arraigned or not.
Yeah, but I don't think he has been. And then another aspect, but notwithstanding the fact that his guilt has not yet been determined, but believe me, about 90% of Nigerians have already considered him guilty.
Well, thank you very much for your time.
Do you understand me? So,
Mark.
thank you.
We're out of time. I would like to continue. I do enjoy this conversation, and I'm sure people are learning very heavily from it, and I hope they keep coming back and learn more. And we'll actually have you on our calendar to be also coming back on May 17th. So hopefully you will sign up more, because we have more opening slots for lawyers. So if you find time, you can always come back for more. And I'm sure people do enjoy hearing from you. I received two comments about your appearance last week. One said, "Oh, that she loved your voice."
And thanks for the compliment.
And the other said that he liked how you break down the law step by step. So that means people are watching you, and people love what you're saying and what you're doing, and how you go about explaining the law to the public. So we wanted to avail yourself more, because this show is going to keep going. This series, the Fundamental Rights series, ends 12th of July. So we'll see how from now to July. So you can sign up more every Tuesday from now to July at 12. Thank you for coming. We appreciate your time. And I'll say, my fellow Nigerians, please keep signing up, keep participating in this show every Tuesday, 9 p.m. Nigerian time, or 3 p.m. Central US time, 4 p.m. Eastern US time. So just join us and participate in the comment section. You see, I was reading out some comment that came through. So I want to hear your comment, I want to hear your participation, I want to hear your question to the guest and to me, the anchor, so that we can learn from one another, so that we can, because when it's conversational, you learn more, because you know, oh, I asked a question and I received answer to my question, and you can able to retain that information long term than just listening passively. Thank you very much for participating. Thank you, Barrister Obin Najofo, and I'm looking forward to having you again. Thank you for your time.
My pleasure. Thank you.